Good afternoon. Happy Wednesday. I am outside if you hear dogs or lawnmowers or anything like that. Uh, Today we're going to be taking a skeptical look once again at a new video put out by Mr. Sanchez. Now, skepticism is where you express doubt as to, for example, the reliability, the authenticness, the relevance of evidence. Mr. Sanchez has put forth evidence, and I'm skeptical of it. That doesn't mean that Mr. Sanchez is wrong. That doesn't mean his attorneys were right. That doesn't mean that he doesn't have good quality evidence available to him. It means that the evidence that he's put out is, in my opinion, lacking. I am incredulous as to the evidence that he's put out. Now, I am also going to be biased. The reason why I'm going to be biased is because, well, I am skeptical of his evidence, and his evidence is already biased because he has put it out, and he is, of course, biased in the evidence that he puts out. He is not fair and balanced because he is, of course, advocating for his particular viewpoint on this. His opinion he thinks is right, and so he's going to put forward the evidence that he thinks supports it. So he doesn't need me to be fair and balanced. He needs you, or you don't need me to be fair and balanced. You need me to be skeptical, to push back on his evidence. So let's take a look at some of this nonsense, and we'll go through it.
Why are there no timestamps on the video?
So this is, I don't know if you can see this. This is questions and answers. So the first one is reason for no timestamps on the video. Now, this is what's called framing. This is a framing device that he's trying to use, because the question is not why are there no timestamps on the video, because obviously you can see that there are timestamps on the video and the timestamps actually work and they run. But they're only in places where they're only in one place. There's only one place that Mr. Sanchez has put those timestamps in. And so the question is, why aren't there timestamps throughout the entire video? That's the actual question. But Mr. Sanchez wants to frame it this way because this is a better way for him to frame it, or at least so he thinks. Let's listen to his answer.
Yeah.
The video provided by the court has no timestamp. It's just one video of a wide-angle shot of the inside of the courtroom, and that's it.
So it's one video, one wide-angle shot of the courtroom, and that's it. So that tells us several things. Number one, it tells us that, well, that must have been Mr. Sanchez adding this timestamp. Why did he do it? Was he attempting to mislead us here, or is he attempting to mislead us here, saying that there is no timestamp? That's a good question, don't you think? The second thing is it tells us that all of the edits that he made and all of the music that he put in was him doing it. This isn't the court editing the video. These are his edits. So everything he is responsible for. And the third thing is this right here on the left-hand side, right there on the edge, appears to be a clock of some sort. Now, we can't see the hours digit of that clock, but we can see the minutes digit. And if he kept it as a wide angle shot of the full courtroom, we would get some sense by looking at that of when exactly things were being cut out and how much of it was being cut out. But he doesn't allow us that opportunity.
It's just one video of a wide-angle shot of the inside of the courtroom, and that's it.
Do you have proof of the time the hearing was scheduled and the time that it was called?
This document is part of the court record.
Let's look at this document. So this is on 3/18/19 at 9 a.m. There's a pretrial conference scheduled at 9 a.m. This doesn't say when the 3/18/19 pretrial conference was. This says there is a pretrial conference scheduled on March 22nd, 10/18 at 9 a.m. So when was this one scheduled for? That would have been up. Up above this, where he doesn't show us, is where they would have set this pretrial conference. Huh? Why doesn't he show us that? He says, I'm going to show you when this was set for, but then he doesn't show us when it was set for, because this is scheduling a new one for the 22nd. Pretrial conference, 3/22. There would be this there, but he doesn't show us that. He doesn't show us that. Why doesn't he show us that? He tells us this proves when it was set for, and it does not. He's lying, or That's my assumption, is that he's lying. Now, the other thing he's going to go with is that this is 8.45/10.48. Tape count, 8.45/10.48. He's going to say that is time. He's going to say this is time. He's going to conflate the tape count with the time. He's going to say his case was called at 10.48, or he's going to say the case was called at 10:48. The case was called at tape count 10.48. Now, where is 1 on that tape count? You don't know, and I don't know. How long are these tapes? You don't know, and I don't know. So all we know is that tape number 32, between tape counts, there's 2 tape counts noted here, 8.45 and 10.48. That's all we know. It could be 8 minutes and 45 seconds long at 10:48 or something. I don't know, but this isn't a time. That is a time. 9:00 a.m. is a time. 8.45 is not a time. So he hasn't shown us. He has not shown us when the case was called. He has not shown it. He hasn't shown us when the case was scheduled to be called. He hasn't shown it. Because remember, this 9 a.m., this is for the next one on March 22nd. And just remember, 10:48. 10:48 is when he was called, according to him, allegedly. But later on, the judge is going to say, you got here 10 minutes ago, which was 10:45, which would mean that he was being called at about 10:55. According to the judge, she's thinking it's 10:45 when she's calling him, and yet this says 10.48, allegedly, according to him. So you tell me which it is. Do you think the judge can't tell the difference between 10:48 and 10:55?
The dates of the hearing, and it also shows where in the tape count the recordings pertaining to my hearing can be found. The first time my case was called was at 8:45. The second.
Now remember, just freaking remember here. Do you have proof of the time the hearing was scheduled? Where's his proof the time the hearing was scheduled? He doesn't show us the time the hearing was scheduled. He goes into when it was called.
Do you have proof of the time the hearing was scheduled and the time that it was called?
This document is part of the court record.
I haven't cut anything off. This is his video. His video.
It gives the dates of the hearing, and it also shows where in the tape count the recordings pertaining to my hearing can be found. The first time my case was called was at 8:45.
No, the first time the case was called appears at tape count 8.45.
The second time, 10:48.
The second time is tape count 10.48. But see, look at this. Look at this. If he only showed this, why doesn't he show us the things he's supposed to show us? This is why I'm skeptical. And also, so bear in mind, the 10:48, if it is, as he alleges, the time and not a tape count, then the judge would be stupid and hear $15,000 cash bail.
On the following court hearing, I requested to be released.
So the defendant must appear. So this is a different document. Okay. This is it's not a continuation of the entirely different document. This is defendant must appear, serve the warrant anytime. So 3/19/18 filed pretrial conference. So the warrant was recalled on March 20, 2018. The recall reason was defendant was booked. So defendant was booked into jail on March 20 of 2018. Bail exonerated. That means his original bail amount was $5,000. His original bail amount was $5,000. Now he has a $15,000 bail amount. On 3/22/18, the final pretrial conference was scheduled for April 30th at 9 a.m. The jury trial was scheduled on May 10th and 11th. So apparently they're thinking it's going to be a 2-day trial, and we're all good. And this time the defendant is in the custody of the Salt Lake County Jail.
I requested to be released, but the judge refused. She wanted to keep me in jail until trial.
She wanted to keep you in jail till trial. Well, you see this thing called bail? That means that's how you get out of jail prior to trial. Now, I want to point out that $15,000 bail is not an exorbitant amount of money for bail. Generally speaking, you could find a bail bondsman who will pay for that bail amount for a tenth. So if you give him $1,500, he'll give you, or he'll pay your bail to the court, and he gets that money back when you appear, and he hunts you down with Dog the Bounty Hunter or something like that if you don't appear. Now remember that that previous bail was exonerated, means it was returned, $5,000, presumably to a bail bondsman, because if he got $5,000 back, if it was his $5,000, then Mr. Sanchez could then just go to a bail bondsman and pay $1,500 and get himself bailed out. Didn't do it. So either Mr. Sanchez could not raise $1,500 to pay for his bail bondsman, or bail bondsman didn't want to touch him, meaning that the bail bondsman, looking back at his records, would say, whoa, this guy is a flight risk. He's at risk to not appear because, number one, he's got a failure to appear. Number two, the court records show that he was late and or absent multiple times. So then you say, well, wait a minute, John. What about his brother? His brother, according to Mr. Sanchez, paid the $15,000 bail. So his brother just walked in with this fat stack, 15 grand, brah-bow, put it down, right? That's how Mr. Sanchez alleges that he got out of jail. Why didn't he just pay a bail bondsman $1,500? Why did his brother have to put the whole amount down? Again, bail bondsman apparently didn't want to touch him. That's my best guess. You tell me how I'm wrong. So trial was scheduled for 5:10, right? Let's move ahead.
You went inside after 9 a.m. People commented, well, he is late, so what is your response?
No one really cares what your response is. Well, at least I don't care what your response is. Allegedly, according to you, you were supposed to be there at 9. Allegedly, according to you, you were there at 9:08. You told the court you were there at 9:08, which means that if, according to you, if you were correct and you were supposed to be there at 9, then you've already admitted that you're late. Again, this isn't school. There's no grace period. This isn't, you're not supposed to be there on or about 9:08. This isn't, I remember back in the old days when I used to have to clock in and out of work, if you clock in more than 7 minutes late, it's going on your time or on your record as a late, because I gave you a 7-minute grace period. This is court. You're supposed to be there at 9 a.m. You're supposed to be there ready to go at 9 a.m. They might not call your case at 9 a.m., but you're supposed to be there at 9 a.m. That is what the court ordered you to do. Anything you could make excuses all day long, but the court doesn't have to accept them. You're supposed to be there at 9 a.m.
My case and over 40 other cases were scheduled to be heard at 9 a.m. that morning with the judge.
He's right, by the way. It's a clown show. You go into, I've been into particular courtrooms for criminal, and there's just, our criminal justice system is overworked. Maybe we have too many laws. Maybe we have too many criminals. Maybe we're too overzealous in enforcing laws. Who knows? I'm not here to deal with that. But bear in mind that there are a lot of people going in and out of this courtroom every day. A lot of people every day. If Mr. Sanchez thinks that he's special, that the judge remembers him, has some sort of vendetta against him, he is wrong. She has probably put hundreds and hundreds of people behind bars. And I'm sure every one of them thought that she was completely vindictive and biased and a terrible person.
Judge Bernard Goodman. Also, before an attorney calls a case, they have to speak with their client first.
That's a lie. Attorneys don't have to speak to the client to call the case. The attorney-client relationship works like this. The client determines what the end result of the litigation is supposed to be. In this case, the end result is you wanted to be defended from these criminal charges. That's the end result. The attorney gets to figure out the processes, the strategies to get there. So the attorney gets to figure out what evidence he needs, what evidence he's going to present at trial. The attorney gets to figure out when he's ready to go to trial. The attorney gets to set those kinds of things. The attorney gets to determine what motions he wants to file in order to try to move things along. Now, a good attorney will listen to the client and will, if the client really wants to file a motion to dismiss, an attorney will, as long as the attorney can make a good faith argument for that motion to dismiss, the attorney will humor him, should humor him. Obviously, attorneys have a duty to not file frivolous pleadings with the court. So as long as there's some legal standing for the motion or a good faith argument to change existing case law, then sure, go for it. But it's still the attorney's determination to figure out what to file, when to file, what evidence to present, what evidence to ask for, and when they're ready to set this for hearing. Remember, this is a pretrial conference. This is where they get together and the judge will say, hey, where are you at in your case? Are you ready to go to trial? Do you need more time? Oh yeah, judge, I need more time. Okay, another 90 days or whatever. Sure, judge. And then, okay. Or yeah, we're ready to go to trial. Okay, trial is going to be set for this date. That's what this conference is for. It's not like the attorney has to ask the client, should we continue it again? Because that's not the client's place. So no. And also attorney should actually inform the client ahead of time, like not necessarily 8 minutes after the hearing was supposed to start, but usually the day before or the week before, you'll have a conference with the client by phone or in person and say, hey, this is what's coming up. This is what to expect. This is what I anticipate happening, right? But there's no need necessarily to speak to your client right before a pretrial conference. There's certainly no law requiring it or rule of professional conduct or anything like that.
They have to know how they're going to proceed with the case before they speak with a judge.
Well, yeah, but that's not for the attorney. That's for the attorney, not for the client, to figure out how to proceed.
Even arriving at 9:15 is not considered late in those type of mass scheduled hearings inside.
Yes, it is. So my experience, again, just 2 county courts, is you go in, you check with the attorney, you check in with not the attorney, you check in with the bailiff, you let them know you're there, you let them know who you're representing, and they'll ask if your client's there, you say yes, no, whatever. Sometimes clients don't even need to be there for some of these hearings. So, I mean, that's usually why they ask. And then the bailiff will let the clerk know, and the clerk will eventually let the judge know or whatever. So, but you have to be there at 9:00. Just because you might show up and you might say, yeah, I'm here. Can you let the judge know? You say to the bailiff, can you let the judge know that I need to speak with my client? We're going to be outside in the hallway, or we're going to be in one of the conference rooms, or whatever. And the bailiff will be like, yeah, I'll let the judge know, or whatever, something along those lines. But you still got to be there at 9:00. Just because you might not be ready to go at 9:00, you still need to be there at 9:00. And that's, again, something that the attorney would have to be ready to go or not ready to go in that instance.
That court. That is why the judge ignored the fact that I told her that I was there at 9:08.
She didn't ignore the fact that you told her that you were there at 9:08. She disagreed with your assessment. She disagreed. She did not believe you when you said that you were there at 9:08. You were there late. You admitted to the court that you were there late. Now, again, this is what the court's saying. We just saw you arrive about 10 minutes ago, which would have been 10:45. Now, if that is true, again, remember that he's alleging that the tape count is actually a time, and the tape count said 10:42. So that means that this judge was wrong. And he actually, if it's 10:55, I mean, if it's 10:55, is it 10:42 or 10:55? I mean, is the judge so incompetent that she doesn't know the difference between 10:42 and 10:55?
And that I had spoken with Heather Chestnut at 9:17.
Again, that doesn't matter. I spoke to my attorney at 9:17. Congratulations. When were you supposed to be here? 9:08. Okay. You were supposed to be here at 9, actually, so you were late.
They didn't want to acknowledge that on the record, so they kept pushing 11:15 as the time I supposedly arrived.
It doesn't matter. You were late.
Has it been reported to the Utah State Bar?
I reported the case to the Utah State.
This is another one of those things that... Let's see if we can't get this moving forward a little bit. Come on, I don't want to... Okay, so I actually did a ramblin' while amblin' about this. This is the Utah State Bar. Now, in Utah, the Utah State Bar has a consumer assistance program, which is designed to provide fairly quick and non-invasive assistance to consumers with their attorneys who are involved in some minor conflict with each other. So that's who he went to. Now, the OPC, the Office of Professional Conduct, they're the ones who investigate allegations against attorneys and LPPs. Those are the paralegals, licensed paralegals, for violating the rules of professional conduct. He went to the wrong program. That's number one. Number two, this is April 30th of 2018 is when his request was dated. His trial wasn't until May 10th, I believe, May 10th and May 11th. So he complained about ineffective assistance of counsel. That's what they're talking about, ineffective assistance of counsel before the trial. Now, the remedy, if you believe you have ineffective assistance of counsel, is to tell the judge, hey, I have ineffective assistance of counsel. I want a new attorney. And the judge, instead of going all the way through trial and then having you appeal it and then having to go all the way through trial again, will most likely say, okay, fine, we'll appoint you new counsel. That's issue number one. Well, I guess that was technically issue number two. Issue number three is this is against Heather Chestnut. Now, his attorney allegedly was Torrance. So who is actually assigned to represent him? Now, maybe it was Torrance, and then he had Torrance, maybe Torrance filed a motion to withdraw because of the relationship breakdown between him and Sanchez. Who knows? I don't, but now it's Heather Chestnut. You typically don't get two public defenders. You have one attorney of record. And so now he's complaining about Heather Chestnut.
I reported the case to the Utah State Bar in 2018.
And again, he should have reported it to the Utah's Office of Professional Conduct.
In May of 2018, they replied, stating they had no jurisdiction.
They did not state they had no jurisdiction. They stated that the bar can discipline an attorney who violates the rules of professional conduct, but has no jurisdiction to grant any relief from the effects that may have resulted from the conduct of the attorney. That's where you file your legal malpractice or your, in criminal, your ineffective assistance of counsel appeal. So they're saying, look, only a court can grant relief from ineffective assistance of counsel. If you write to the state bar and say, my attorney gave me ineffective assistance of counsel, they're not going to really be able to do much for you, generally speaking. You have to allege that they violated one of the rules of professional conduct. Now, this is interesting because they cite Rule 1.2 of the Rules of Professional Conduct, which states exactly what I told you, that the lawyer and the client have the authority and responsibility in determining the objectives to be obtained by the lawyer's representation. The lawyer basically has to agree to allow the client to hire him, and the end goal of the representation has to be something legal, but that's really about the end of the attorney's involvement in that. The lawyer is required to abide by a client's decisions regarding the objectives of the representation, provided the objections sought by the client are not illegal and not prohibited by the lawyer's professional obligations. It is also the lawyer's responsibility to consult with the client regarding the means whereby these objectives are to be obtained. However, the lawyer has the responsibility for determining the means and tactics to be employed, the evidence to be presented, etc. So he wrote to the wrong place, and he alleged the wrong things.
That I had to bring my complaint to the same court.
You did not. This nowhere in this document does it say you have to bring your complaint to the same court. If you go through trial, you're in a worse position. You should bring a motion for new counsel before trial, because again, he filed this before trial. He should bring it before trial because then he could appeal that. It gives him a basis for appeal. Well, I shouldn't say that necessarily. I don't know Utah state law to know if he can appeal that particular decision. But I'm assuming that he could, or at least maybe go for a writ, if not an appeal. I'm not entirely sure because I don't practice law in Utah. But that would be a decision of the court that either could bolster his later appeal after trial, or maybe he could raise some appeal or writ right then and there, and then maybe have a second shot after trial if the court turns it down. Who knows? I don't practice law in Utah, so I'm not trying to give legal advice on that. But your first remedy is to go to the court that you're in and say, look, I need a new attorney. The second thing that you would do is then appeal afterwards. If you don't get a new attorney, you appeal and tell the Court of Appeals that I had a bad attorney.
That had conspired against me. They practically...
And now he just said that they conspired against him. Again, he keeps throwing out this conspiracy thing. We'll see that come up later. And again, he writes to the state bar about prosecutor, what does he call it? Prosecutorial misconduct by Mr. Swift. You're never going to win on that. First of all, again, it's the wrong place. He should have written to the Office of Professional Conduct. That was issue number one. Issue number two is it's ridiculously hard, if not impossible, to get a prosecutor on prosecutorial misconduct because, again, to bring the case, all the prosecutor needs is probable cause. Of course, to convict you, he needs beyond a reasonable doubt, but just to bring the case, just to bring charges, all he needs is probable cause. So, yeah, they don't have any jurisdiction over it, yada, yada.
Ignored the accusations of misconduct and distorted my complaint so they wouldn't have to take action against any of the
Wrong freaking place, dude.
people involved.
They didn't distort anything. Wrong place. You screwed up. You screwed up.
How is the lawsuit going?
And just so you know, look at this. It literally says, as far as the assistance or the consumer assistance program is concerned, consumer assistance program, wrong place. Office of Professional Conduct, right place.
How is the lawsuit going?
Out of 4 causes of action that I've raised in the lawsuits, 1 has been dismissed. The other 3 are still standing.
A plaintiff in a case like this needs to come forward with evidence showing the basis for a claim of a conspiracy. And as in the Abercrombie case, I conclude that there was no genuine issue of material facts concerning the existence of conspiracy. Because of the lack of evidence of a conspiracy between these two public defenders on the one hand and the prosecutor or the judge on the other hand, I conclude that there is not a basis for allowing a Section 1983 claim based upon a conspiracy. Therefore, I conclude that the Section 1983 claim should be dismissed with prejudice.
All right. So there's a couple things there that I think you should be aware of. There's no genuine issue of fact, which means that Luis Sanchez didn't even properly allege. He didn't state allegations that, if true, would have shown conspiracy. You can't just say, oh, they conspired against me. You actually have to allege facts, at least in California, that, if true, would show that there is conspiracy, or there would at least be, something that the jury could use to find that there was conspiracy of some sort. So he didn't even allege enough to have his 1983 claim stand. He didn't even allege enough to get past a motion to dismiss that claim. Summary judgment. I don't know exactly what they did or how they called it in Utah, but he didn't survive it, which is like surviving a motion to dismiss is like the easiest thing ever, because all you have to do is allege sufficient facts. It's just you saying, yeah, they did this, they did this, they did this. That's all you have to do. So your facts are pretty bad. You're pretty poor if you can't even allege facts sufficient to make a legal question about whether or not there was a conspiracy there. And then dismiss without prejudice dismiss with prejudice means that he can never raise that particular issue again. Now, I don't know about the other 3 causes of action. Apparently 1 is legal malpractice. I don't know if that has survived a motion to dismiss. I don't know. So I guess we'll find out. But remember, this was filed back in, I think, November of 2020. So this may be the first round of motions to dismiss. There may be more coming. This might be the final one. Who knows? I certainly don't, but it's going to be interesting to see the way this shakes out. All right, now I'm assuming that what he's doing by this, he puts 2 things up here. First of all, that she recuses herself. And the second thing is that she retires, right? So I think he's trying to make an argument that she retired because of his video. So this says, and I'm going to assume this is true. It does appear to have a valid seal on it, so I'm going to assume it's true. Based on a video posted on YouTube regarding above defendant's case and possible perception of bias or conflict, I am hereby recusing myself. The court refers this matter to the presiding judge of this district for reassignment. This court takes no action. So this is May of 2018, May 23rd of 2018. So in February of 2019, that's what, 7 months later? Yeah, 7 months later, she retires. And this guy has the brass clackers to say that she's retiring because of him. No, she recused herself because you are putting out things that she thinks might give a perception of bias on her part. And that's proper for a judge to do. Oh, you think that I'm biased against you? I'll recuse myself. Fine. She's got plenty of other cases to deal with. But to say that she retired because of him 7 months later? No, son. No. Yeah, that's still a stretch too far. All right. So apparently that's it. Thank you for watching. I hope I've given you something to think about. Be skeptical. Be skeptical of me. I've had plenty of people who think I'm taking money from the defense for this, although I don't know why I would if I am an attorney. If they wanted to hire me to work on the case, they probably could come up with a reasonable amount of money that would get me involved. They have not done so, though, I assure you. Thanks for watching. Have a great day.